Good morning. Good morning. Welcome everyone to today's session. We are having our monthly money meeting, and the July one will be focusing on estate planning and succession planning. We started this monthly money meeting a few months ago, where on the first one we spoke about spending and budgeting, and then we spoke about using credit wisely. And then last month we were talking about saving and investing. And today we've got our special guest, Gerrit, who's going to be taking us through estate planning and succession planning. So everyone who's here, feel most welcome. This is going to be an engaging session. It's going to run from 8 to 9, and we're going to have time to ask questions, engage, and thereafter we'll do follow-ups and be able to assist you should you need further assistance. Gerrit, over to you. But before we do that, I just want to recognize and note our BC, Chekani Brighton Moyane. Thank you for joining us and also for your work in terms of making this possible. So everyone, you're most welcome, and over to you, Gerrit. I think he's no longer in the meeting. But while we wait, everyone, you're most welcome to then just share on the chat functionality in terms of where you're joining us from, and also your expectations when it comes to the session. When we say estate planning and succession planning, what comes to mind? What were your expectations when you signed up for this particular monthly money meeting? Gerrit, over to you.
Thank you very much, Matayeni, from ImPowerX, for inviting me today for this meeting. It's an honor for me to just speak to you guys today about the importance of estate planning and touch a bit on business succession planning. So if you just give me a moment, I just want to share my screen with you. Just to show my face, that you know who you're talking to. Here from Nelspruit and Mbombela side in Mpumalanga. So I'm also working that side in the Limpopo side, and I'm currently working as a Liberty legal specialist for a few years now. And previously I was also practicing as an attorney, so from that space into the corporate side. So yeah, hopefully it can be a valuable session for you today. Just give me a moment to share my screen with you.
Thank you. There's a good morning from Puti on our chat. Thank you for joining us, Puti Mutapo. I know you are based in Polokwane. Gerrit says he's in Mbombela, Nelspruit. Puti Polokwane is represented. I'm in Limpopo, in Thohoyandou. So yeah, let's see and hear from the others. Where are you joining us from?
Can you see my screen?
Yes.
Okay. Is it in presenter mode, or you can only see my slide? Is there notes as well?
There's notes as well.
The notes as well. Okay, I'm just gonna. Okay, now you can only see the slides.
Yes, perfect.
Okay, guys. So as I mentioned, we're going to talk about the importance of estate planning. So to start today, if we go to our table of contents, what will it talk about? We'll talk about what is estate planning, who needs estate planning, who should be involved in estate planning, the aims of estate planning, our tools for estate planning, the essentials checklist, estate duty, which you pay to SARS, the important estate planning documents for safekeeping, when to revise your estate plan, and then also business succession planning, buy and sell, key person, and contingent liability. Okay, so firstly, if we get to what is estate planning, guys, you must just please, if you want to ask a question, just unmute yourself and ask a question. I'm not able to see any questions in the chat box while presenting, so please just stop me and ask a question if necessary. Okay, firstly, so if we have a look at what is estate planning, so we must first ask ourselves, what is an estate? So if we talk about an estate, what would you say is your estate? So basically, it's your assets and liabilities. This will include, let's say, your assets. Under your assets, you will have your house, you will have your vehicles, you will have furniture, you will have your bank account, and except your business will fall under your assets. And then when it gets to your liabilities, that will be your credit card, your long-term loans, and so forth. So then from there on, if we get to estate planning, so basically, what do we do for you as financial advisors, and what does ImPowerX want to assist you with as a financial advisors industry? They want you to help you in terms of to preserve, to increase and protect your assets. They want to ensure that there's effective distribution of the assets, and they also want to take your wishes into consideration. We need to do this to ensure that we make provision for the people that stay behind should you pass away, as well as to enable you to settle your debts and don't leave a burden for the other people staying behind. Estate planning is not only about drafting a will. I know there's a lot of us not having wills, but this is very important, and I'll get to that as well. It's also not about writing life policies or reducing estate duty, but it's some of the important points that we need to assist you with. And it's also not a once-off activity. Ladies and gents, this is not something that we do once off and we forget about this, because there's some life-changing events that might happen in the future, and then we must review your plan actually. So it's actually something that must happen on a yearly or an annually basis. We'll get to more detail in terms of that as well. So who needs estate plan? Is it only the rich people? Is it only the middle-aged people? Can we do estate planning if you're maybe older or if you don't have any money? Estate planning is for everyone. So it's not just for the people with a lot of money or the young people. We need to do estate planning for everyone, because in the end, all of us will pass away. All of us need to retire. So it's very important that we do a plan for everyone. And evenly, if you don't have money now or you feel you're too old, there's a saying that say, all the small fish also gets big. So we must start when it's still small, and we can help you build your personal and your business estate to something much bigger. Okay, so even if you're single, married, divorced, have minor children, it doesn't matter. You need an estate plan. Each one of your plans will be unique. There's not a set structure for every person, so it will be different. Each person has its own circumstances, goals, and objectives. So it will be personalized to your own unique plan. We also need to review regularly to take account of personal and legislative changes, as I've mentioned before. If we talk about legislative changes, it means that should there be a budget speech in February, there might be changes that we must take into consideration. Or if there's certain acts that they change, we need to bring that into account. So we need to review this regularly. So who should be involved in your estate planning as a client and as an individual? So firstly, you can involve the attorney to help you with some legal documents drafting, like your will. If you need a trust, they can help you with trusts and so forth. Your accountant, which can help you with the tax planning, and then also your financial planner, which will be your ImPowerX in terms of ensure your liquidity, help you with the estate planning, help you with your retirement planning and your business planning and so forth. So what will the team do? They will basically assist you to develop and review a estate plan. They will brainstorm around a strategy, and then they will also assist with what the tax implications and costs will be should you pass away. It's not only by having a plan, we should also execute this plan, and that's why we're here to help you with. If we get to the aims of estate planning, so why do we do estate planning? So firstly, we want to achieve efficient deceased estate planning. So guys, these days, when you pass away, it can take quite some while to go through the whole process of going to the master's office and finalizing the estate. Or if you don't have a will, it can even take longer to finalize your estate, to pay out the money and so forth. So we don't want to struggle with that. So if your estate plan is in order, it will make it much quicker and much less trouble. Secondly, why do we want to do estate planning? We want to appoint beneficiaries as per your choice and wishes and your advice. So if you want to leave money or a life policy for someone specific, you can do this while you're still alive, and we can assist you with that. It's not only by appointing a beneficiary, but you must also know what the implications will be by mentioning someone specific as a beneficiary. So, sorry, does someone have a question? Okay. Then we need to provide liquidity. What does that mean? If we talk about liquidity, we're talking about having enough money to actually settle your debt should you pass away. So we want to ensure that there's a surplus in funds in your estate when you pass away, that you're able to settle your debt and not leave the burden for your family. We want to provide for dependents and to protect minor children. So in our plans, we'll make provision. Let's say, for instance, your spouse will need 20,000 Rand a month should you pass away for the next 20 years. We'll do the calculations and we'll tell you we need an amount of 1 million Rand to actually provide for this dependence of yours. If there's minor children, we also need to make provision for them and to ensure that should you pass away, that they are looked after. We want to minimize tax implications. So it's not just about living your life and passing away and paying no tax. We all know SARS wants their part of tax. So we want to try and minimize this tax when we do the plan. So it will just enable your family to actually get more money and live a better life going forward. 6, we want to have future growth of your assets. So it's not only when you pass away, but if we do the correct planning, we can also assist you with some growth of assets. And then we want to provide for unique circumstances. We want to take account for any offshore assets if you do have offshore assets. We want to look at your will. We want to minimize your costs, and we want to ensure the plan that we have is practical, legal, and efficient. And there must be some flexibility in the plan because we need to review it and make some changes here and there. Okay, so what will we use and what's important for you when we look at estate planning? So firstly, we look at the will. So guys and girls, please remember that it's very important that you have a will in place. If we don't have a will, it means that the Interstate Succession Act will come into play, meaning you won't have an executor, so you'll have to nominate the executor. You must approach the master. Your wishes won't be taken into consideration. So if you want your spouse to inherit it 50% and the other 50% maybe to a friend, you won't be able to do so. Because in terms of the Interstate Succession Act, your spouse will be first in line, and from there on it will be your children if your spouse is not alive anymore. So there's a set structure when you don't have a will in place. If you have a will, you will be able to nominate specific people to actually inherit from your estate, and it gives you some options. If you don't have a will, you won't have options. So this is a very important estate planning tool, and I would say that please guys, if you don't have a will, you can approach ImPowerX to assist you with that. They can refer you to someone if need be, and we can just get that into place. It's the first most important step of estate planning. We also want to have a will because we want to reduce estate duty. Why will we reduce estate duty? So basically, if you give your assets to your spouse, you will be able to save on estate duty. If it goes to anyone else, then you will pay estate duty. I'll get to the estate duty tax just a bit later in the presentation. We also need the will to make provision for our dependents. So we can state there that the assets of my estate must maybe go to a trust, or we must maybe use a certain amount of money to maintain a specific person. Let's say you want to leave some cash to use when you pass away to look after your mother or your father. You can do that as well. We want to achieve efficient administration of the estate. As I mentioned before, these days, bigger estates can take 5-6 years to finalize, which is just crazy. So if everything is in place, it can just be much quicker when you pass away. Then if you want to make any bequest, leave a cash legacy to someone, that's where your financial advisor will help you to ensure that there's sufficient liquidity, that there's money left after you paid your debts, and you can leave this money then to whoever you like. Then if we get to trusts, we got two types of trust. We got the living trust and the testamentary trust. I don't know how many of you is actually involved with trust, but if you are, just some background of what specific trust this is. So living trust, that is basically a trust that you create while you're still alive. That's why it's actually mentioned as a living trust. So you'll create it now, you'll have choose your trustees, you create it, you pay the attorney now to help you creating it, and it's in place. You don't have to worry about it. You can use the trust whenever you want, but there will be yearly costs that you'll have to pay. You'll have to have an accountant there. So it's not just by having a trust. It's not always that easy, but it can work in certain circumstances. Then we get the testamentary trust. What does that mean? So if you have a will, you can use the will, and as soon as you pass away, you can create a testamentary trust, meaning that the trust will only be created when you pass away. In that trust or in your will, you will nominate the trustees of the trust, and you can also then beneficiate this testamentary trust, or your money can go to this trust, or your life policy can go to this trust, and from this trust, you can look after your family. The reason why you will create this trust is that you don't give money to your spouse and she spends it or he spends it with the new girlfriend or boyfriend. So guys, it's also an important thing to do if you also have minor children, because you want to ensure that you look after your minor children. If you have money and you don't have a will and you don't have a testamentary trust, for instance, you don't have a guardian in your will, what will happen? This money will end up at the guardian's fund, which is looked after by the government. And every time your child needs something from schooling, or they need money for university, you need to apply to the government at the guardian's fund to actually help you with that funds and give that money to the children to pay the school or whatever the case may be. And as soon as they attain a certain age, the money that's left will then pay out to them. So these days, a lot of us don't really want the government to work with our money. So if you don't want them to work with your money, you can please create the will, nominate a guardian, or create a testamentary trust, which is a safer option. And you can't do this without a will. So just bear that in mind. Then donations. So we can make donations to our spouses without paying any tax, and then to anyone else who have a yearly exclusion of 100,000 rand. So if you want to get some assets out of your estate or money out of your estate, please remember that we can do donations up to 100,000 tax-free annually. Then if we get to appropriate matrimonial property routine. So, yes.
Before we move to the next slide, there was a question here from Busisiwe. It's around estate duty, to say that if you don't, what happens if you don't have a spouse? Are you going to be liable for estate duty? And can one nominate an alternative guardian just in case the preferred one passes away or for some reason unable to fulfill their duties?
Yes, so if you don't have a spouse, you will still, let's say if you have a will and that assets that's left, or the money that's left after you pay your debt, you say, okay, it must go to my children, or it must go to my friend, or it must go to my mother. then you will still pay estate duty. The only time you don't pay estate duty is when that assets go to your spouse. So if you don't have a spouse, anyone else that gets that assets will pay estate duty. And to get to the guardian question, you will be able to, in your will, to nominate more than one guardian. So you will say the successor of this specific guardian will be X, and then if the first guardian won't be able or passed away in the meantime, the second one will be able to be the guardian of that children. So yes, it is possible.
Thank you for that response. The comment there was, sure, I think people are ready to go and get spouses for estate duty purposes. But with that said, I think just to add that it's a Section 4Q deduction, where whatever you are leaving to the spouse, then you can be able to get a deduction when we do the estate duty calculations in estate planning.
Yeah.
However, there is also the abatement that is available, where certain amount you don't pay estate duty on that. So it's not all lost because people don't have spouses that they're going to pay estate duty. There are instances where, depending on your estate, you won't be paying estate duty, which is why it's critical that we do your estate planning and then also be able to see what is relevant to you and how you can structure your estate so that you best benefit. Thank you. You can continue.
Yes, that is 100% correct. The only thing that we must bear in mind is, should you be married and you actually your spouse inherit all your assets, there won't be estate duty payable, but then all that assets carry over to your spouse. Should your spouse then pass away, then your children will pay estate duty. So guys, it's also important that we remember we don't only do estate planning for the husband, we must also do estate planning for the wife, because if the husband passes away today, everything goes to the wife, and if the wife passes away the next day, then the children will pay estate duty because there's no other spouse. So it's important to do it for both parties. In terms of the Section 4A abatement, if your estate is smaller than 3.5 million, you're not supposed to pay estate duty. But if it's bigger than 3.5 million, you get to paying estate duty. So everyone that will inherit from you or your estate, your estate will have a responsibility in paying a proportionate estate duty should it be over your 3.5 million abatement. Okay, so if we get to further to our tools, choosing an appropriate marital property regime, what does this mean? So if you are still single and you met the person which will spend the rest of their life with you, and you want to get married, it's very important to choose the correct marital property regime. What does that mean? So we have three choices when it gets to marriage. Firstly, it's in community of property. So what does that mean? If you are married in a customary marriage, you will be married in community of property. If you didn't do a contract and registered it at the deeds office, you will be regarded as in community of property. If you are not married in terms of customary law, but you also did not do a contract, you will be regarded as in community of property, meaning that you and your spouse have one estate. It's a joint estate. So 50% of all these assets and 50% of all your assets will actually fall into one estate. So if your husband thinks he's got a business and it's his business, but he's married in community of property to the wife, then actually the wife is owning 50% of his company. So also in terms of the debt, if the husband's got a lot of debt, this is actually also the wife's debt. So it's very important for us to understand in community of property means you have a joint estate. It's not separate estates. What's his is yours and what's yours is his. So it's basically you don't have your own assets and you don't have your own debts. Okay. Just to come back to that, if you had an inheritance, maybe from a mother or father, that will be outside of the joint estate, so it won't fall part of the estate. But if you are actually in community of property without any inheritance or so forth, basically the joint estate will be 50-50. If we get to out of community of property with the accrual, what does this mean? So when you go to attorney and they assist you to draft a contract and you sign that contract and you include the accrual, it means that the growth between the estates. So let's say, for instance, you guys started, you were still young, you don't really had any assets, so the value of your estates was 0 and 0. Now, when you get divorced or pass away 10 years later, the husband's estate is worth 100,000, the wife's estate is worth 50,000. So what will happen now? The difference in growth between the husband and the wife, which will be then the 50,000, it will be divided by 2, so it will be 25,000. So that 25,000 will go to the spouse, which got the smallest estate. So if you've got the biggest estate, you will pay something to the guy with the smaller estate or the lady with the smaller estate. So out of community, it means your assets is your own assets. So it's not a joint estate. But if you have the biggest estate, you will have to pay something to the person with the smaller estate. So that's what the accrual actually means. If you go to out of community of property, this is just straightforward, ladies and gents. It's your assets, it's yours. So you don't share assets. Should you pass away, or should you actually get divorced, no one will get your assets. It will be your own. So in your will, you will be able to say we must get it, but it won't automatically just fall back to your spouse. Except if you don't have a will, then interstate succession will kick in, and then your spouse will actually get it. Okay, so everyone happy with your marital property regime? Any questions in regard to that? Okay, everyone happy?
Yes.
Okay, then
everyone happy.
100%, thank you. Then when we get to using life insurance to assist with liquidity, what does this mean? So when we assist you with your estate planning and we see that there's a shortfall in your estate, so let's say, for instance, your assets are worth 1 million rand, but your debts and the money that you need to provide for your family, you only have, it's 2 million maybe that you need, but you only got 1 million. So what will you do to actually make up that 1 million that you need? Then it's where we do your estate planning. We'll tell you, listen, sir, or listen, ma'am, you actually need another 1 million rand to make provision for this. So it's not easy just to get to 1 million. It's not for, we're just starting to save 1,000 rand and then we're getting to 1 million. So the quickest way to make up this 1 million rand shortage will be to take out life insurance. We don't know when will we pass away, if it's maybe tomorrow, if it's in a week, if it's in 10 years. But guys, I'm telling you, this is very important. Should you have a shortfall in your estate, that we look at life insurance or some savings, at least, if you don't want to go the life insurance way, but we need to make provision in some way. So that's also very important, because we need to replace the income to maintain your spouse and children. We need to pay estate expenses. You have a funeral, you have income tax that you need to pay. So we need to make sure that there's enough liquidity in your estate to actually pay this. And as I mentioned, if there's anything left, you can actually leave a legacy for your children and let them actually live a good life, or at least give them a good startup. Then if we get to our living annuities or our annuities, what does this mean? So a lot of us are working for companies where you might have a provident fund or a pension fund, or if you don't work for a company, you have your own business. You can also have a retirement annuity, meaning all these three, the provident pension and retirement annuity, is tools that we use to make provision for retirement. So you start saving monthly. You also get a tax rebates for actually paying money into your provident pension or your retirement annuity, meaning that you'll pay less tax yearly. It also helps you when you pass away, the money that's left will go to the people that's financially dependent on you, and it won't fall into your estate. So retirement money or pre-retirement money It won't have estate duty on, so the money that will be, let's say you've got 1 million rand in your retirement annuity, that full 1 million rand will go to your people that's financial dependent on you. Then when we get to retirement, early retirement is currently at 55 years old, so you can retire since 55, but it's not easy these days to retire at 55 because life expectancy can these days be between 85 and 95 years old. So people are getting quite older these days. So guys, if you retire on 55, you've got quite a few years to survive from your retirement money. So you need to start saving for retirement as well. Start when you're still young. If you're not young anymore, start at least. We need something. You can save on estate duty, you can save on income tax, and you can at least have some income when you retire. You don't need, if you still want to continue working and you retire, you can, but I'll just say keep onto that money until you really need to retire, then you can retire. But that's also part of the estate planning that we assist you with. We will say, you will tell us, listen, when I retire, I need 20,000 Rand a month. So we'll do the calculations for you and we'll say, okay, you're currently 30 years of age. You want to retire on 60. So for 30 years, we must save X amount of money to actually let you retire with a specific income that grows with inflation, maybe with 5 or 6% yearly. So we also do that planning for you. And it's very important that we not only look at when we pass away, but also when we stay alive and actually retire. And then also the tools is the tax structuring that we assist with. So what is the essential checklist when it gets to estate planning? Firstly, as I mentioned, which is very important, is you must have a valid will. Yes.
There's another question. Say, does this mean that you can access your money sitting under preservation funds at 55?
At what age?
55.
Is it a pension fund or is it a provident fund? Or
no, preservation fund.
Preservation, but provident preservation, pension preservation.
Yes, I think with both, maybe let me tackle that to say that yes, you can access it because if you resign before age 55, then you can use the preservation fund as a product while you wait towards retirement. And when you reach 55, that's a retirement age where you can retire or you can access money from your preservation fund.
Yes, so basically when you, let's say when in 2018 you resigned and you had a provident fund and there was 100,000 Rand that paid into a preservation fund, you will be able to access the full 100,000 even if you before 55. But guys, you will pay a higher tax bracket if you access the money before retirement. If it's a pension preservation, so if you have had a pension fund, you can only access 1/3 of the money. So that was still a difference between pension and provident fund. It changed in 2021. So basically, since 2021, any money that you put into retirement, you will only be able to access 1/3 when you retire and not the whole full money. So we don't have access to all the funds from 2021. The government changed it around, but there's a lot of changes happening currently. They also want to include like a savings pool in your retirement money. So if you have an emergency, you will be able to access some of your money from that savings pool. So it's not in place as yet, but they are busy working on it. But currently, your money before 2021, if you're under the age of 55 or over the age of 55, you will be able to access your provident fund money. But if it's pension fund or it's a retirement annuity, you won't be able to access that money. You will need to retire before you can get access to that money. Everyone with me? Okay.
Yes, thank you.
Is there another question? Maybe.
Not at this point. We can continue.
Okay. So as I mentioned, it's very important to have a valid will. When it's a valid will, I'm not going to go into all the formalities, but basically you will appoint the executor. That will be the person that looks after your will should you pass away. They will go to the master. They will do all the administration work. They will be able to sell the assets according to your wishes or distribute the assets according to your wishes. And you will also have witnesses that sign your will. You must sign the will. And how will we know that you do have a will? It's basically if we have sight of the will, or your attorney had sight of the will, at least we know it's in order. It will stand before court and before the master. It's always very important to have original will, because when you pass away, the executor must have the original signed will, which must go to the master. If you don't have an original, the executor will have to approach the court, and the court will actually have to go through an application and accept a copy as the original. So what I always tell guys is, if you do a will, let's sign 3 original wills. You keep one with your financial advisor, you keep one with your attorney, and you keep one at home maybe. So should you pass away, then at least someone's got an original copy, which just makes it easier. And who is responsible for helping you with drafting a will? You can draft a will by yourself, at least if you feel comfortable and you know that it will be valid and you know maybe some of the requirements. But I'll suggest that you use one of your professional teams members, which will be your financial advisor, your attorney, or your accountant, which can assist you with this. Then what must we also have in place? Sufficient liquidity. That means you can pay your debts, you have money to pay it, you can leave a cash legacy. How do we know it? We'll do a liquidity calculation for you, and that's the responsibility of your financial advisor who will assist you with that. The same, we need capital to replace the income and to make provision for the dependents if you pass away. We'll do a capital provision calculation, and that will also be done by your financial advisor. Then the same when it gets to a funding mechanism. As I mentioned, we don't always have the money to provide for liquidity. So that's why we will, or you will take out life insurance to make provision for that, or the executive will have to sell some assets to make provision for that, and your financial advisor will help you if you need to do some life insurance policy or disability cover and so forth. Then we get to SARS and to tax, the one that all of us doesn't like. So how much do you actually pay? Guys, if your estate is more than 3.5 million, but it's below 30 million, you actually pay 20% estate duty, which can be quite a lot of money. And just to add on there, having a life policy and the beneficiary on a life policy. And if that beneficiary is not your spouse, that specific person will also have a responsibility to pay estate duty. So it's not just giving a life policy to someone. If you want to give someone 1 million rand and you know there's going to be 20% estate duty, you must actually give that person 1.2 million rand, because 200,000 will go for estate duty. So if your estate is below 30 but above 3.5, you pay 20%. When it's above 30 million, you pay 25%. This is a lot of money, guys. So we must do planning to make provision for this. If you structure your stuff differently, or your assets and liabilities differently, your business, then you will be able to get some specific points where you won't pay estate duty on. So it's very important. When you make donations, as I already mentioned previously, 100,000 rand a year exemption, and it works the same as your estate duty. Any donations to other people above 100,000 per annum, you'll pay 20% donations tax, below 30 million, and above 30 million, 25%. So let's say you donate 200,000 to someone, it's above 100,000 more than your exemption. So you actually pay 20,000 rand or 25,000 rand donations tax to SARS for giving that 200,000 to someone. Executor's fees. So if you have a will and you nominate this specific executor, the specific person to look after your estate when you pass away, there will be fees involved. It can be up to 4.025% of your estate. So you can negotiate this to be 0.5 or 1.5, all depending on the person that you use to assist you with this. If you work with a bank, you'll most probably pay the full executor's fees. But guys, it's a lot of work. So paying this small percentage might actually be worth it, but you can negotiate around executives' fees. If it gets to fees to the master, the highest fee that you'll pay to the master will be 7,000 rand, and that's not a lot of money. So there is like a certain, it can be much lower, but a lot of estates max is 7,000 rand. Okay, so if we look at important estate planning documents, we look at your will, we look at your ID for personal information, your marriage certificate, your anti-nuptial contract, your divorce and maintenance orders, if that is also there. If there's a maintenance order, that order will also have a claim against your estate to make provision for maintenance for your children or your spouse. If you have a trust, a copy there of your bank accounts, your credit cards, source of income, details of insurance, medical aid, income tax, investments, motor vehicles, houses, other assets, liabilities. And guys, it's important just to maybe keep a file at home or give some of this information to your financial advisor to keep on file for you. Because if you have, let's say, for instance, accounts that your spouse is not aware of, or you have some investment somewhere, or you have a house somewhere that no one knows about, it just makes it difficult when you pass away and no one is aware of that, because in the end, it will just delay the estate process, finalization of the estate. So just tell someone maybe about this. So should you pass away, we at least know where to start when we need to work with your estate. So it's very important, estate planning documents.
Thanks,
When
Kira.
do you need to?
There's another
Yes.
question
Okay.
that came through, but before getting to the question, I'm just laughing. I'm like, don't tell your spouse, tell your financial advisor. The question says, I heard that you can also use your bank to deposit a copy of your will, especially if you don't have a lawyer. How true is that? I think that's referring to the safe custody.
Yes, so it is possible. You can ask your bank to either assist you with drafting a will, or if they don't assist you and you already have a will, they can keep it for you. They call it safekeeping, and yeah, you will pay a fee for that. It's not for free. So there is a yearly fee that you pay for the bank keeping your will safe. It's definitely possible. Just keep in mind there's a fee. I don't think it's much. I think it's like 250 rand a year or something like that. You can just maybe find out with the bank if you want to give the bank your will for safekeeping.
Thank you.
Okay. Pleasure. Okay, then when do you revise your estate plan? So now we've done your estate planning, and we've done, let's say, for instance, 2 years back, and we just touched it last year. We see everything is still in place, and now this year times are tough and you're not happy at home. There's some violence, domestic violence, or your husband doesn't like the children anymore. What do? You get divorced. So when you get divorced, you must immediately tell your financial advisor, because we need to make some changes to your plan. Why? Because you maybe want to change your beneficiaries on your policies, on your retirement annuity, your trust, because maybe your husband or your wife was this, they were the beneficiaries on this. Now you pass away 3-4 months down the line, what will happen? That money will actually pay to them. Even if you're angry with them, the money will still pay to them. So it's important that you review your plan as soon as you get divorced. So that's a very important point when do we need to revise your estate plan. Also, if you get married and you've chosen your marital regime, as we discussed previously, it might have an impact on your estate plan. So we need to review your estate plan and ensure that it will actually be in line. The birth of a child, if you get a child, we need to make provision in your will to protect your children's inheritance. We also need to make provision, maybe if there's if they need money to go to university or for their schooling, we can take out some life insurance or some education insurance to, if you pass away, they can pay for your children's schooling. Or you can also look at some kind of investment that you save monthly for your children's schooling or so forth. Okay, then downturn in financial position, it's not always when it goes good when we need to assist. So there might be situations like, for instance, with COVID, that we need to review our stage plans. We maybe had to sold some of our assets. We maybe it wasn't going good with the business, so we need to do some restructuring in your plan. And then also, if you have new business ownership, business succession planning, very important. What will happen to my business should I pass away? Who will get my business? Is there money to pay the debts? So it's very important for us to do business planning as well. And then, as I mentioned, changing legislations like the budget speech, we need to look if everything in your plan is still in order. Okay, so guys, that's more from a personal side. So we just touched base on some important estate planning stuff in terms of your personal life. So now we're just going to touch on business succession planning. I'm not going to go too much into detail today, but why do we need to do business succession planning? So you have a business and you have one shareholder, you two shareholders currently, and 50-50 in the business. So should you pass away today, what will happen to your shares in that company? If you don't have a will, it will go to your spouse. They will get into the business. Let's say, for instance, the husband is an engineer and they've got a construction company. The spouse is an accountant. The wife is the accountant. Now, suddenly, the husband passed away, the engineer passed away. What must happen to his 50%? Now it goes to the spouse. She's an accountant. She maybe knows nothing about the engineering business or construction business. Now, suddenly, she gets the 50%. How will the other partner feel if this spouse suddenly is now the new partner of this business? It won't work, guys. This other shareholder coming into the business, they don't have the knowledge maybe to assist you. Maybe they can't keep the same clients. You don't want to sit with a situation where you struggle with the nephew or the aunt or a friend that doesn't know anything and just making a big mess there in your company. So we need to make business succession planning. How will we go about this? Either, let's say this company is valued 1 million rand, you've got 50%. So now you've got 500,000 in shares. So if you pass away this 500,000, the other partner must buy you out, or you must buy out the other partner. So you must now have money, the 500,000 rand, to actually buy out this guy, because to finalize his estate, we need to buy his shares. Or if you don't buy it, it will just go to the spouse or to the friend or whoever. But if you don't want that person there, you want an option to buy out the shares. If you don't have money, what will you do? You will need to go and make a loan to actually buy out the shares from the other person. So now you must go and take a loan of 500,000. Now it places you actually behind because you don't have the money. You need to buy the shares. Now this business have a loan at the bank of 500,000 rand. So how can you go about not actually need to have money to buy the shares, or how will we go about that? I'll get to that just now. I just want to let you think a bit around that. This business can also have some debts. So if we pass away, the bank can come to my estate and say, okay, you had a loan of 1 million rand to buy this business property. Now we want to claim this 1 million rand from your estate should you pass away. You actually wanted to give this money to your children to actually make provision for their studies. But now you need to give this million to the bank. So how can you actually avoid this situation? Then you can also have a very important person in your company. This person knows all the clients. They have a speciality. Should you lose this person today in this company, it can be horrific for this company. You can actually lose the company. You can lose a lot of money. So what do we do actually to ensure that should this person pass away, that we have plans in place? So this is all things that we must remember when you think about your business and your succession planning for your business. Who will take over your business? How will you manage to have money to buy the shares? How do you keep important people in your company? and how do you pay the company debts when you pass away? So firstly, if we look at, they call it contingent liability. So if you go to the bank, you take out a loan, the bank will ask you, okay, you two partners, okay, both partners will now have to sign a contract. In this contract, they call it, you sign surety. So what does that mean? If you sign surety, it means that if the business doesn't have money to pay this debt and you pass away, they can come to your personal estate and actually sell your assets or get money from your estate to pay this loan. So if you sign surety, you must take out a contingent liability life insurance policy to ensure that should you pass away, this policy pay this debt and it's not a burden on your estate, or even the other partner staying behind, that is actually, or if you the partner that's staying behind, that you actually have money to settle this debt and the company can continue forward. We don't always have this money at hand, so it's very important to look at contingent liability planning. Then if we get to our buy and sell, so what is a buy and sell? So this means if you have two partners, the one partner pass away, you will have the first choice to actually buy out this other shares. You don't get someone else involved in the business. You will become the 100% owner of this business. How will you do this? You can put a life policy in place. You can use this money and you can buy out the value with that life policy. You don't need to you don't need to get a loan. You don't need to steal money somewhere. You can actually just use this policy to buy out the shares and everyone is happy. You have the business. There's no new person in your company and you can just continue with the business. Appoint maybe a new director or bring in someone else from into the company that it's your choice. It's not just someone randomly. So you can use this succession planning to help you with your business. And then lastly, we get to our key individual. As I mentioned, you can have a very important person in your company. What will happen if this person pass away? It actually means you have a loss in revenue. So how do we protect this loss? What also happened is this guy, you spend 20 years in actually helping this guy to get to that point. He's got all the knowledge. And now suddenly you must head on someone else from another company. You must pay them a higher salary. You need money to do that. So by using a key individual succession plan, you will be able to place money into a life policy or to take out a life policy. And should you pass or should this person pass away, it will pay that money to the company and the company can use that money to either help them growing the business or to help them replacing this specific key person. Yeah, so it's very important, guys, if we look at business planning, this is some key factors that we need to take into consideration with our succession planning. I'm not going to go into too much detail now. I see we're also at the end of the session. I don't want to keep you longer than an hour. So that's basically it from my side. I don't know if you guys just want to take some time, if there's any other questions from your side.
Thank you very much for the presentation. If there is any other questions, you're most welcome to unmute, or you can just use the chat functionality. But as we do that, I just want to thank you all for joining us this morning. And this recording will be available. We will share it on our YouTube channel, which is ImPowerX Advisory Services. And there was just a comment on the chat where was sharing that this is a crucial discussion which we hardly think of or put in place as we collaborate or form partnerships. And I was saying that that's why we are here as ImPowerX Advisory Services, because with us, it's all about taking financial literacy education to our communities and also assisting with flexible financial planning that suits the needs of individual businesses. So depending on where you are and what you want, we are available. And one thing that Gerrit always says is that if you want us to assist, we are always available. So that's what we echo as well as ImPowerX, to say that if you would like to set up some time, let us look at your current situation or the business that you're running, the collaborations and partnerships that you're getting into, and also your own personal estate planning in terms of, is there a will in place? If there's one, is it being reviewed, and all the things still showing and speaking to what your wishes are? And Lolo is saying thank you very much for this session. To you, Gerrit, and also to Brighton, thank you for making this possible, being part of this session, and also ensuring that our people are getting to know about the importance of estate planning, and also being able to see what they can do in order to take the next step. Because most people, when you say estate planning, when you talk about wills and trust, they think it's for other people and not for them. And this just made it practical and simple so that they know how they can use this to their advantage. Yeah.
That's good. If there's some interest, we can maybe in near future also do a session just more focused on the business planning, and I can maybe discuss in more detail around the succession planning, as I just mentioned, in terms of your buy and sell, contingent liability, and key person. So if someone have an interest in around that as well, we can maybe have a session and we can go into a bit more detail in terms of business planning.
Thank you very much. And that brings us to the end of the session. Thank you all, and may you have a beautiful day further. Thank you.
Thank you.
Keep well, guys. Cheers.
Thank you so much. Enjoy your day.